obviously, I think a lot of client complaints are based on personalities, right? That's the one thing I'll always tell my client is I need to understand by talking to you who your client is, because just because they've submitted a written or oral complaint, you may still have to report that, but will it become anything else is a question that no one knows for certain, but we can make an educated guess by saying, this person is full of hyperbole versus, hey, I did a Lexis search and I was able to find that this person has sued 2 other advisors in the past, or, the attorney on this case, I know them from prior experience. There's a lot of kind of judgment calls that we can make to better understand what needs to be done. Like, often there's almost always a duty to report to the carrier. However, when you report to the carrier, you can get a lost run. So you might say, hey, let's not ask for any defense over here. Let's just kind of keep it as a notice or a circumstance, etc.
Well, hello there and welcome to the Advisor's Edge podcast. I'm your host, Rob Jacomen, and I'm joined by my co-host, Chad Ramberg. How you doing, Chad?
I'm doing great. It's good to be here today.
Awesome. We have a very special guest and a very hot topic for all of you today. We have Emil Ali from McCabe Ali, who is basically, they're a law firm, and I will let him share more, but I want to welcome you, Emil, to our show. And why don't you do this? Why don't you tell us a little bit about yourself, your firm, the who you serve, and the problems you help to solve for clients?
Oh, well, thanks so much. I'm glad to be here, Rob and Chad. Well, first of all, I'm very excited that you're excited to have me, because most people don't love being around lawyers. Lawyers are usually kind of coming in at the last moment, telling people what not to do, and then charging them a lot of money. So I'm glad to just be here and have a casual conversation. But a significant focus of my practice is representing investment advisors, right? I represent investment advisors, broker-dealers, help them in all aspects of departing a firm, what we call like transitioning from a wirehouse or one advisory firm to another. We help them with compliance, hopefully not, but if it needs to get to the point, we help them with litigation or even transactional matters like, for example, business continuity. And then, of course, related to my background, I worked for quite a few years at the Department of Labor. We do a lot of work with ERISA. And, I've been doing this for a long time. I've worked with advisors of all sizes, whether they're state registered or SEC registered, and of course, FINRA member broker dealers. And, it's when I'm like talking to a friend who's like, oh yeah, I got a speeding ticket. Can you help me with that? I'm not the guy for them, right? But I get to nerd out when I talk to investment advisors that are like, hey, you know what? I have this non-compete or non-solicit, how do I, start my own firm and be able to still interact with those clients? Or, hey, there's this new rule that came out with the SEC, how do I interact with that? Again, to most people, very boring stuff, but hopefully to you guys, some really interesting stuff.
No, we can nerd out on that stuff.
Yeah. I mean, it's vital for our clients. And one of the coolest things, Emil, is your legal background. So, there's a lot of great compliance firms out there, but the depth of your legal background is just fantastic. And so I'm curious how that for you kind of reshapes or what does that make compliance look like to you? Of course, that's a huge question. So go in whatever area you want to kind of focus in there. How does that change your view?
Yeah, that's a really good question. So, we talk to people at all stages of their process. For example, if there's somebody leaving another investment advisor, they're probably talking to us. They're probably talking to a compliance consultant, and then maybe somewhere in between, maybe another lawyer or another compliance consultant. So the best way that I try to explain this is, for the most part, you're going to be okay with whoever you go, whether you're doing a transition or you're looking for compliance help. A lawyer can provide compliance help, but the way that I look at it is I'm not always the right person, and a lawyer is not always the right person for every situation. I like to say that legal and compliance are like a Venn diagram. They have some overlap, but for the most part, legal is a complement to compliance, right? It's somewhat of a different service. Again, the people that are doing the service, at least from the legal perspective, can have some overlap in compliance. Compliance can't always have overlap into legal, but as an example, a client is threatening to sue you. Do you need to call a lawyer? Well, not necessarily, because they haven't actually sued you. I wouldn't say it's 100% needed, but you probably want to get some advice. But can you at least get some advice from a compliance consultant? Well, you can get the advice on whether it needs to be reported on your Form U4, et cetera. So there are some things that a compliance consultant can help you with. But I also transparently tell my clients that if you're looking to outsource your compliance services, for example, email review as for an SEC registered advisor, don't hire me, right? It's not worth paying me to review your emails. I mean, in a pinch, I'll do that for you, but it's not really worth anyone's kind of effort to do that. That's much more suited to a compliance consultant. So in my work, I have advisors small and big. I have the small under 100 million that are state registered. I try to keep those very limited in what I do. Then I have kind of like that sweet spot of probably 200 million to 500 million. Those are the folks where there's often a compliance consultant. Then there's like the owner who's the CCO, and then there's me. And when the compliance consultant and the owner maybe have some disagreement or want to bring something up, they'll come and say, hey, Emil, what do you think about this? Could you give us an opinion? Can you add into this? Or, hey, we have this legal question because we need this contract redrafted, or we have an SEC exam. And then there's the big advisors, the multi-billion-dollar advisors. They have their own CCOs. They're not using compliance consultant. They might call me to do a mock exam. They may call me again to do legal questions. So it kind of runs the gamut in what I do. But at the very core, I will always tell people that I am a complement to your compliance program or your compliance consultant. And I think that's really important because I know sometimes compliance consultants are often afraid of me. They're like, oh, the lawyer's coming in and he or she is going to take over and do these things. I'm like, no, I work best, I would say, when there's a CCO or a compliance consultant that knows what they're doing and knows when to ask for help.
That's great. I mean, I think another way so I'm making an assumption here because we'll work a lot of times with clients, something's keeping them up at night. They maybe ask their compliance consultant and I just tell them, if it's keeping you up at night and you think it could get into a claim, let us know and we can help bring some resources to help potentially, well, it's all about mitigating it, but you would have a better set also to help navigate that to keep it out of a claim, if at all possible, from a legal perspective, not just compliance. You can go a little bit deeper there is what it sounds like. Is that too much of an assumption?
No, I think that's true. I mean, I hate to say it, but part of it is just sometimes the gut instinct, which for me is based on experience, because I have seen these cases from the beginning, right? From when they're simply an allegation to the end through settlement and things like that. And I know sometimes what ticks. Obviously, I think a lot of client complaints are based on personalities, right? That's the one thing I'll always tell my client is I need to understand by talking to you who your client is, because just because they've submitted a written or oral complaint, you may still have to report that, but will it become anything else is a question that no one knows for certain, but we can make an educated guess by saying, oh, this person is full of hyperbole versus, hey, I did a Lexis search and I was able to find that this person has sued 2 other advisors in the past, or, the attorney on this case, I know them from prior experience. There's a lot of kind of judgment calls that we can make to better understand what needs to be done. Like, often there's almost always a duty to report to the carrier. However, when you report to the carrier, you can get a lost run. So you might say, hey, let's not ask for any, defense over here. Let's just kind of keep it as a notice or a circumstance, et cetera.
Absolutely. Yeah. That's why sometimes talking with us will help keep it from that actual, because I'll tell them sometimes, look, we don't need to report this. We're not going to let it doesn't need to be known. If we can get there early enough and help, that's really cool. Well, when it comes to keeping folks up at night, advisory firms, what are you seeing out there as kind of some of the typical things that are keeping advisors up?
Sure. So one, I would say it depends on whether they're SEC registered or state registered, because there's a whole host of problems. Part of it just comes with how many clients you have. Maybe you have just a lot of clients because they're SEC registered, or versus just a few clients because they're state registered. But the other thing is also if they are also affiliated with a FINRA member broker dealer, aka dual registered, they're going to have
Mhm.
different issues than, for example, somebody that's fee only. So what I would suggest that somebody kind of look at would be, what are your weaknesses, right? And sometimes I cause people to not be able to sleep at night because, they tell me, hey, what are my biggest risks? Or, hey, I saw your, email blast that said, here are things that the SEC is looking at. Can you tell me what's wrong with my firm? And that's a loaded question. But I tell people, listen, the rules are kind of written in some ways a very black and white way, the regulations, the interpretive guidance, or the statute itself. And your job is to basically enforce them, to create policies, enforce them, test them, etc. But my job as a lawyer is sometimes to also look at it non-binary, to look at it in a gray area. So it's not just black and white, there's some level of gray. But the problem with compliance consultants is their job is not to find the gray area. Their job is to make sure that you're complying with the text of the rule. And sometimes that's where I talk to people and says, hey, a client told me they're unhappy with the way XYZ custodian sends out their statements.
Yeah.
Okay. And is that a client complaint? And the compliance consultant said, yes, that's a client complaint. And, they call me and they're like, I have to report this on my U4. And I said, well, if you report it on your U4, now you're going to have to get it expunged years later. And I was like, to me, that's not a client complaint. And I can see how the compliance consultant might say that, but it's something that I think you should write a memo about. But the memo should be, we received this, we analyzed it as a client complaint, but the client was not complaining about the conduct of the custodian or of the advisor or the IAR. Instead, they were just providing feedback, which we brought to our custodial, business development person and, just gave them some feedback. That's it.
Right. What's the difference between a complaint and a feedback? It's an area. Yeah.
Exactly. And true story, I've had that happen. And in one case, it was a dual registrant. Their broker dealer actually considered that a client complaint and said that they should have reported it.
Man.
And yeah, it was a series of a lot of different things like that. But it was, and I looked at it and I laughed, and my client was just like so serious, like what's going on? And I'm like, I just think this is ludicrous. But there's a saying for lawyers: reasonable minds can differ, and I think I totally understand that. So I respect whether another lawyer, another compliance consultant, or somebody in-house in a position of power is going to look at something differently. And my job is to help the client say it in a way that respectfully says, hey, we disagree, and can we get to this avenue? Because a lot of people say, oh, lawyers, we litigate, we do all these things. Yeah, we can do that, but we don't want to do that. It doesn't work out most of the time. The only person that gets a benefit out of that is the lawyers, right? No one else. The client, the opposing party, no one's going to be happy. In the end, you would have just spent a lot of money trying to fight. So if we can avoid fighting and just communicating effectively, I think that's one of the biggest parts of my job.
Boy, that's a clip we're going to point out. Communicate effectively. Let's not fight. It makes sense.
Actually, I have a question. Can I follow up with something? So one of the things I hear the most from advisors in general, I would say RAs and other types of advisors, is really from the marketing and business development perspective. So, Emil, what have you seen as the greatest challenge for a lot of these firms in how they market themselves, how they generate new business? Because obviously that's a concern of theirs. They want to grow their firm. They want to grow their business. They want to get new clients. But what do you see as like the greatest challenge and bottlenecks that are kind of like, no offense to anybody here, but I always used to say when I was in the insurance industry that underwriters can be one of the sales prevention department. I also sometimes feel like when I'm talking to advisors that compliance can be almost like the sales prevention department. And I don't mean that in a disrespectful way. I just mean that there seems to be a little bit of tension there between what's appropriate in terms of marketing and growing your business and really focused on that growth. What have you seen in terms of that area of your practice?
Yeah. So one, the marketing rule has really changed the game a little bit positively and a little bit negatively, right? Negatively in the sense that there's new, questions you have to answer on the Form ADV Part 1. There's new record keeping that you have to do. But in a positive way, it's allowed you to do things or made things a little bit more flexible. And I will 100% agree with you that a lot of my job is a CCO coming to me and saying, hey, my IR, my owner is mad because I said that they could not, publish LinkedIn posts about XYZ unless they get pre-approved, and I have not approved these. And that's like literally a common question. So what do I do? And I say, hey, okay, you said everything correctly. That's in line with the marketing rule, in line with your compliance procedures. There's not really any way about this. Hey, maybe we can pre-approve certain types of statements, but you just need to pre-approve them or approve them in advance of them being published. But what's stopping you from approving these posts? And then I'll look at the post and be like, oh, this doesn't make sense, or this is promising something. And I would not approve these posts. So I think a lot of it is a disconnect between compliance and the advisor. And so like one of the top things I saw during COVID was the use of social media channels to get clients, because you weren't going to golf courses. You weren't doing all the traditional stuff. And to be honest, not that people were going to golf courses to meet advisors, but a lot of times you meet in person. Maybe you meet them for coffee or whatever. Now you're like, well, I want to go on TikTok or I want to go on Instagram and make short videos. Great. The problem is, as an advisor, you have to be very careful what you say in comparison to the random other person that's talking about financial coaching, which is not regulated. Financial advisory services are regulated. And even if you're not necessarily talking about financial advisory services, maybe you're talking about financial coaching, as an IAR to a firm, you are subject to certain compliance and marketing provisions. So I would say it is a very, very big issue that I see. And, it causes a lot of, discontention within firms. And again, this goes back to what I said about communication. Communicate, right? Yeah. Explain. I definitely agree that CCOs and firms have to have some flexibility, but there's certain things. Like the other probably big issue right now that I see is off-channel communication. The SEC has been really, really big on that. And off-channel communication to you sounds really bad, but it's AKA texting, right? So, you and I might email each other, and you and I might even text each other. I might say, hey, Chad, I'm going to be late to our phone call. And that's normal for us to do. But with an advisor, it's actually not generally permitted. Why? Because that text message is not being monitored and archived. So, there's ways to do that, right? There's phone systems that can allow a CCO to review the text messages, save them, et cetera. There's special CRM systems that have texting only phone numbers. There's so many ways to do this. Or there's the old screenshot thing that people were doing. Previously, a lot of firms would just say, hey, we want you to only talk to people by text, to tell them to, hey, you need to move over to email, or, we can't communicate by text, or, hey, we're going to be late. But people are saying, well, we have especially younger clients that all they do is text. They don't want to talk by phone. So even though that's slightly different than marketing, in some ways it is, because if a client's texting you saying, hey, I want to have a meeting to learn more about your services, and they're only wanting to text, you're like, hey, let's talk. And they're like, no, we don't want to talk on the phone. That creates a problem, because it's hindering your ability to bring in that client. So the only thing I can tell you is that it's a big point of contention, and just we're in a highly regulated environment, and I think we just have to find a happy medium. But most of that is just communicating between the firm and compliance, as well as the advisor or the IAR.
Well, that brings up a really good point. Are the regulatory agencies and entities that obviously want you to monitor these kinds of things, are they addressing these issues that you're bringing up right now? Like, what is their game plan to address some of those things that might be for someone like myself? It's like, hey, it's no big deal, you're texting, whatever. But to the world that you're in every day, that's a big deal. But what are the regulatory organizations doing to address these underlying things that are issues?
So, I mean, the SEC came out with this marketing rule a couple of years ago, and I think that has addressed some things. But the way I would say it is, and this is not trying to, demean the SEC by any means or any other government agency, but they're always going to be behind in the times, right? Let's face that.
That's what I was going to ask you about technology, because technology is going at the speed of light. You have AI now, and you have all these tools and all these things that are going at the speed of light. And how do they stay like up to speed with all that stuff?
Yeah, it's hard, right? So like, for example, federal government has a specific law they have to follow called FISMA, the Federal Information Security Management Act from many years ago. And it, restricts the security protocols of certain things. And you understand government's more likely to have people trying to hack them, et cetera. But, when I look at when I communicate with the SEC, we have to do it through WebEx, not through Zoom or Teams or anything like that, right? I mean, WebEx is from 15 years ago, but and it's kind of a joke, but I think we're always going to see them having a little bit of maybe a 10-year gap between what they're doing now versus what the rest of the world is doing, what they're understanding. So I definitely think that's one issue. But the other issue, like if you're a state advisor, you're like, hey, the old cash solicitation rule was in some ways adopted by many states. They have not adopted the marketing rule. So I'm state registered. We often look to the SEC, can we follow some of the new benefits of the marketing rule? And sometimes the answer is no. But yeah, I mean, I definitely think that there's always going to be a differentiation, whether it's the use of AI, whether it's the use of certain new types of social media that may come up now or in the future. There's always going to be people that do things at the outset, and sometimes it's better to seek forgiveness than permission. That's all I'm going to say. But you got to make an educated and informed decision on what to do. And I'll give you another example. Right now, a lot of advisors with the SEC are using something called Pantera. I think now they're called FIEX, or maybe it used to be called FIEX. Now it's called Pantera. I forget. But it's a way to basically look at held away accounts and trade in them. And, we've had these for a long time. There was an older version called Buy All Accounts, which I think was owned by Morningstar. But right now with states, they're sending out letters. Missouri, California, and Washington, as far as I know, have three that each said, we don't like this. And yet millions of people are using this. Millions of clients are using it, especially with SEC advisors. I have SEC advisors, big and small, using it. And then I have some state advisors that are doing it. And I'm in the middle of exams where the state is saying, no, you can't use this. And, my question to them very respectfully is, why? They're like, oh, well, you don't get copies of the custodial statements. You don't get this, you don't get that. And I said, well, that's because, that's the job of this company to receive all these things. Oh, well, you're not verifying that the fees are correct. We'll say, well, hey, we're looking at the fees. We're, the client's looking at the fees. Everyone's looking at it. It seems to be fine. But examples of that are new technology. And I wouldn't even say Pantera and FIEX, they're not AI. They're not extremely new technology. They're just a tool to help advisors do their job better. And guess what? The benefit of Pantera is that you're not worried about rollovers because you're keeping this money in a held away account. So that might be better for the client. The client wants your help, and you maybe say, hey, rolling over is not good for you because you have a really good platform over here, really good, there's no fees in your 401k. I'm going to charge you a very small fee to just manage the assets. And now the state is saying, no, we don't want you to do that. We'd rather you have them roll over and not get a good benefit. I mean, that creates a little bit of a conflict just because the regulator doesn't like it. So I mean, I think there's a lot of issues where we just have a disconnect between what the regulator's doing and what what advisors want to do.
Absolutely. Yeah, I've run into that too with clients. In fact, an interesting thing is we had a client who recently, he was just on that edge between state and SEC, and he decided to move his own assets into the firm to take them into SEC. So the regulatory structure changed, which is, he's fortunate to be in that position, but it's an interesting mechanism. I'm curious from your perspective as an attorney and the work that you're doing with a broad range of financial firms, how it looks. We have an interesting, I should say, with firms breaking away, deconsolidation, and then you have I think we're always going to have a lot of M&A activity as advisors, get closer to retirement. And so there's some mergers and some separations all at the same time. How does that environment look to you? And if you can give us any insight on down the road, what it might look like.
Yeah. So speaking of RIA consolidation, I mean, I would say, what was it, 2020, 2021, and 2022 were amazing. I mean, I did so many of those M&A transactions, and people were paying, like, I had 6x. I mean, I think Thrivent was paying so much for firms, which was great for my clients. But now it has slowed down significantly. Valuations have gone back down. They're still pretty high, but they're closer to what they were 5 years ago. Mm-hmm. But it doesn't mean that consolidation is over, because people are still retiring, et cetera. But I would say some of the key issues are business continuity, right? The SEC is asking, why don't you have a business continuity plan? What happens if you're temporarily or permanently disabled? What happens if you pass on and you're a solo? Or even if you're a 2-3 person firm, who's going to take over ownership? We don't want this stuck in probate or something, right? And you don't have to be registered to own a firm, right? Especially at the SEC level. So, what do you have in place to continue operations? That's going to be really, really important. The other thing, post-COVID is remote work, right? It adds flexibility, but it adds some complexity as well, because now we have, I remember one of the best questions that I got from a client was, I have this, employee, they're pretty new. We just hired them, and now it's April and we're working from home. Am I supposed to do anything to verify they're okay? And I was like, well, I think one of the things you should do, because none of these people had ever worked remote before and now they're new, is like ask them about their home environment, ask them to show you where they're going to be working, have a policy in place that says, don't show your screen to anyone, like even your spouse or your significant other, whatever they might be. Those are all kind of really important issues. And I think I'll pause there to say that this is kind of aside from consolidation and growth, is one of the things that the regulator wants to see is a policy or procedure in both, and then a testing of that policy.
Right.
And sometimes,
are you following your policy that you set up?
And is it working? Right. Yeah. Because sometimes you can have a policy and you're not following it, and that's worse than not having a policy at all. But, having a policy is really, really important. And some people just say, oh, we don't need to worry about this right now because we're too small or too this. The SEC still wants to see that. And, you want to avoid getting in trouble. You want to avoid getting a fine. And believe me, people get efficiency letters all the time. They're very, very common. So small things are fine, but you want to avoid the ire of the SEC. You don't want them to think that you're kind of an evil doer. So it's really about creating these. And sometimes it's just an exercise in futility, but just do it, right? Just get something on paper, get something reasonable on paper, not just, remote work. Just work hard. That's not a policy. Yeah. Remote work policy is, ensure secure environment. Just Google something, put it together, and slap on, one page into your compliance manual. That's probably better than anything. But going back to the consolidation issue, one of the issues I see, kind of like what you said, is advisors trying to do something to get SEC registered. Sometimes it's, hey, let's two of us join forces. We're not really going to buy each other's firm, but we're going to join forces and kind of be tenants in common, so that each of us with 50 million can now become 100 million. And, we'll find a way to split our revenues and do something. And that, everyone wanted to be, they wanted to get independence, and they got their independence. And now they're like, hey, you know what? I want to get to SEC. Good idea. That can be good for certain people. Just always create a structure. You want to understand, like, before you get in bed with another advisor or get into this, talk, communicate. And then reduce to writing, even if you don't have a contract. I mean, I'm always going to say as a lawyer, have a contract, but just put together some bullet points about what's going to happen, right? That's really, really important. Like, hey, this is how we're going to split the money. Or if we can't agree, this is what we'll do. Maybe we'll hire a mediator. Maybe we'll go to XYZ person to kind of figure out what to do next.
Well, I got to say that the things you're going over, so many nuggets of wisdom and things to think about for advisory firms. And also just areas where, if you get here, then you want to think about this or that. I really appreciate all of this. And as we go through that, the other thing, and we're getting close to the end of our time, and I just want to say thank you so much, Emil, for being here. It's really cool. if someone's listening right now, and there's always changes coming up from a regulatory standpoint, is there a regulatory item that's either coming up soon or a hot topic to keep in mind or think about? Maybe they should research a little bit more to help them be ahead of the game. Is there anything like that you can share with us?
Yeah. So, I talked about off-channel communication, and maybe this is more for SEC, but a little bit for states. Off-channel communication, something called hedge clauses. There's this idea, from a lawyer's perspective, hedge clauses are totally legitimate. It's this idea that you tell a client, hey, we're not going to be responsible for if a third party does something, or if you lie to us, we're not going to be liable for that. Seems legitimate, right? Happens all the time. When you sign into Gmail, you're probably agreeing to a click wrap agreement that says the same thing. Well, the SEC says that's not fine. Even if you have a savings clause at the end that says, hey, nothing in this paragraph is going to impact your rights under federal or state law, they say that's too confusing. And the SEC wants to get rid of it. We kept pushing back. And now we're at that point where the SEC is taking enforcement action against people. So, my advice to my clients is get rid of your hedge clauses. Unless you're willing to kind of put up a fight, it's the easiest thing to do. Is it going to cause an avalanche of new litigation? Probably not. It may allow, like, the normal plaintiffs' attorneys that we have that are representing investors, they don't care about the hedge clauses. The people that I care about is like, the my cousin Vinny of the world that's going to be like, oh, I read this and it looks like we can't sue them because, we lied to them.
Hey, I love that movie. I mean, come on.
That attorney might now say, hey, I think it's easier to sue. But it's one of those things that's on their radar. The marketing rule compliance is on their radar. And then just in general, how you're actually engaging in your compliance reviews. So for example, are you doing best execution reviews? Are you reviewing emails? Are you doing all these things? And again, one of the things that you'll always hear me say, and anytime I give a continuing education, is if it's not in writing, it didn't happen. And just put it in writing, right? Say that you did something on a specific date, and it's going to help you tremendously.
That's fantastic.
I agree. Well, is that?
Yeah, sorry, that's a timer, so we make sure and keep on time. I know you got a lot of important things to do, Emil. Rob, you have a great closing question. We love to just help kind of wrap it up.
Yeah, Emil, we are so grateful and honored that you decided to come on and share those insights with us. And I just think you're so sharp and so professional and just loved everything you said today. I think there's so much more we could get into, and
Yes.
I hope to have you on again at some point, because I have tons of questions. Here's my closing, and I love asking this question because it really brings things down to a more personal level. So I want you to imagine for a minute, you're retired, you've been in the business for a long time, and then you're looking back on your career, and maybe you're sitting in your rocking chair or you're on a beach somewhere, and you're thinking about your legacy, and you're thinking about the impact that you've made on people in your life and in your career. What would you want people to remember you by as you're looking back on your career?
That's a really good question. I have two young kids, and I'm always telling them that, obviously work hard and you'll be successful. And, it's not always about working hard. A lot of it is about luck. A lot of it is about, how you interact with people. And so I think beyond hard work, it's about the relationship that you build. So I am not the right attorney, or in case that's also an option for a compliance consultant, I'm not the right person for everyone. And I'll always tell people when I talk to them that you need to trust me and my experience and my gut instincts. That's how it's going to work, because I'm trying to build a long-term relationship. You might call me and say, hey, I have this problem with the state or the SEC. Can you give me some advice? Yeah, I can give you advice. Maybe it might take a couple hours. Maybe it might only take 15 minutes. But I'm trying to connect with you for the long haul. And sometimes I'll tell you, hey, I don't think you need me. But I think it's really important as a lawyer, human being, somebody trying to build that relationship, that you as a potential client, as an advisor, you talk to different folks to get a different perspective. And, no one's going to give you the answer because they're not going to understand all the facts and issues. But to understand their experience, their thought process, That's to me very important. So I will always tell clients to interview especially other lawyers or compliance professionals before they make a decision. So they might say, hey, we want to hire you today. Unless it's a huge emergency, I'm going to tell them, don't hire me today. Why don't you here's another person to talk to. Here's 2 other people to talk to. Or most people have already gotten referrals to other folks. Talk to them and tell me who you want to go with. And it may not be me, right? I'm not the right person for everyone, because I want people to look back and say, you know what? I worked with Emil for 15, 20, 30 years. And he was there for me during my darkest hour, or he answered that small question. And now I had him on speed dial that 5 years later, when I had a problem with a client or had a problem with a regulator, he was there and he already knew how things were operating in my business, right? Because I'm trying to build that long-term relationship so that I already know what you're doing. Lawyers, by the way, are reactive. Like, we're not going to tell you, hey, by the way, you need to do X, Y, and Z. It's more like, hey, Emil, we have this issue. How can we address it? Like, a little bit more reactive, but I want to be reactive in a very positive way.
Love it.
That's great.
Chad, you want to close this? You want to bring us home?
Well, I think I don't know that I can say anything better than what Emil has said. You know, your time with us today is greatly appreciated. Like Rob said, sometime happy to have you back. And you know, what I would say is your level of professionalism, and the word of the day is communicate. You're helping advisory firms communicate at a higher level to clear things up and keep it going well. So thank you so much. We all strive to be as professional as that, and you've given us some great ideas on how to elevate the work that we're doing. So thank you.
Thank you both.